A big development in the case against Bill Cosby. 5 women who say the once revered TV dad sexually assaulted them will now be allowed to testify in this retrial next month. A Pennsylvania judge ruling yesterday they can tell their stories. The accuser at the center of this trial, Andrea Constand. Bill Cosby is facing 3 counts of aggravated indecent assault for allegedly drugging and assaulting her in 2004. This is the second trial, of course, on those charges after the first one ended in a mistrial. Joining me now to discuss, HLN legal analyst Joey Jackson, criminal defense attorney Bob Bianchi. So as we look at all of this, Joey, Cosby's spokesperson says, and I'm quoting here, "This shows how desperate the prosecutors are, and this is a very weak case." Is that just the defense attorney doing his job as the defense attorney? Or do you agree? Well,
yes, there's an element of that, of course, because you're a show person, showman, right, or show person in this instance. But the reality is that I'm outraged by this ruling, completely outraged by this ruling, and let me express to you why. Is there legal precedent for the ruling? Yes, and let me explain the law. In the event that there are prior bad acts that a defendant commits, and it goes to motive, it goes to common plan of scheme, it goes to modus operandi, it goes to absence of mistake, it goes to identity, you could admit that evidence. The problem that I have is that it is so overwhelmingly prejudicial as to not have a place in this trial. In my view, and it's always been my view, trials need to be about what they're about. I want to know what you did to me today, not what you did last week, last month, the week before. Now, here's the argument the prosecution makes. But we're only admitting it to show his modus operandi. We're only admitting it, Your Honor, for the limited purpose of showing that he's done this before and it's part of a common plan of scheme. Nonsense. The jury is not going to parse hears and the judge instructs you, ladies and gentlemen, you're only to consider it for prior conduct. You're not to consider it as to whether he did this now. They're going to consider it and say, look, he did it last week. He did it the week before, the month before. He did it 5 times. You're guilty. Big game changer. Wrong decision. Final point, Bob. I know you got a lot to say, and that's this. It's the law of the case. The fact is that there's a doctrine called the law of the case. You can't now on a retrial change the precedent associated with the case. I just think whatever viewers think about Cosby, right? Whatever you think about him, he's a molester, all the 60 people are right. I think trials have to be fundamentally fair. And this makes it unfair, and I think it's wrong, and I certainly wouldn't approve.
Except that, Bob, before you speak, you did say that there is some precedent here. So it's not completely out of the realm or out of the that it would happen.
Erica, great point. There is precedent for this, but essentially it's a case-by-case basis, and prosecutors have to be very careful because you might win the battle and the jury convicts.
Right.
But the appellate division is going to be looking very closely to determine why they convicted. Were they assured of Andrea Constand's story, or did they just think he was a bad guy from all he did? And therefore, I think I want you to evaluate my case based upon what my client is accused of, not what he did before.
Bob,
Sorry.
do you agree? Because I have to say, for each point that you make, I feel like somebody can make a counterpoint and say, but...
Always. Especially this distinguished gentleman.
Joey's legal analysis on this evidence rule we typically in most states call 404, other act or bad act evidence, is spot on. But there are exceptions, and that's why there's the precedent that Joey is speaking about. And those exceptions, as he indicated, are common plan, scheme, motive, opportunity, absence of a mistake, identification, just like Joey said. What the prosecutors argued in this particular motion was that these individual females are going to be able to support Constand's testimony by showing similar conduct. I agree with Joey as a prosecutor who used to have lots of 404 bad act evidence. You've got to be very careful that you use it in a very surgical and circumstantial way, or circumscribed way, so that the judges down the road in the appellate division don't sit there and say, wait a minute, this became just a trial about bad character, and this was just a pile-on with Bill Cosby. So, yet, nevertheless, though, the judge was kind of circumspect. He said, I'm not going to let you prosecutors introduce 18 victims' testimony. You got 8, you can choose 5. Now, the fact of the matter is, Joey is right. This will be an appellate issue down the road. But as far as the prosecutor is concerned, those 5 witnesses make the critical difference. It's a game changer in this case.
It'll be interesting to see, again, the trial. Jury selection, I believe, begins in 2 weeks. Trial is set for the first week of April. We've got to move on to this next one. So this is a story we've talked about here on the show. A former YouTube prankster now going to serve 6 months in jail after shooting and killing her boyfriend in a botched stunt. In June of last year, then 19-year-old Mona Lisa Perez and 22-year-old Pedro Ruiz planned to fire a gun at a book while Pedro was holding it to his chest. They believed the book would stop the bullet.
Told me about an idea, and I said, don't do it. Don't do it. Why are you going to use a gun? Why? Because we want more viewers.
Well, they did it, and the book did not stop the bullet. Ruiz died, and then she was arrested, pleading guilty to second-degree manslaughter. So this week, Perez took a plea deal, a 180-day jail term with 90 days in home confinement and 10 probation. As we look at this, Bob, I'll let you kick this one off first here. Was this a reasonable plea deal? She is young, and we talk a lot about rehabilitation.
One of the biggest powers I had as the prosecutor was to be able to use the rule of reason and wide discretion in handling cases.
Amen.
He involved himself in this. It was a terrible and stupid accident. It's no different than the cases that I was in charge of that dealt with Russian roulette scenarios gone awry, people who leave their kids in a car and they die of heat stroke. The woman is going to be suffering enough that she killed her boyfriend and also the father of her children. I thought the prosecutor's actions here were measured. She's going to be responsible by way of a conviction that will follow her the rest of her life. She's going to do a little jail time. But like I always used to like to say to my staff, Erica and Joey, I know you don't think that most prosecutors look this way, perhaps, but you don't need to always hit a fly with a sledgehammer in the criminal justice process. I think it was a measured result.
I think those are the words of a very measured and reasonable prosecutors, and us defense attorneys love to see that. Just listen to me. You don't have to agree with me, but listen to me. And if what I say makes sense, then maybe I could bring you on in my direction. The problem is that we're so polarized, even in courtrooms. I want 10 years jail. You know, I want probation. Can't we meet in the middle? Here as a defense attorney, I think it's the absolute right move. Someone was dead here, and she was horrifically exercised horrific judgment in shooting him. I don't care, Erica, that you say, well, do it. He said I should do it. He said it was only a prank. He got a book and an encyclopedia. It wasn't going to go through. What she did was horrifically wrong. She needs to be punished. The 6 months is punishment enough. She has 2 of his children. It's the right call. 10 years probation as opposed to 10 years jail. And thank goodness the prosecutor was measured in this approach. You don't need to send her to jail. She's a mother of 2.
Gentlemen, appreciate it as always.
Good work, sir.
Thank you, sir.
Look at that common
Reasonable
ground we just
prosecutor.
found there.
I love it.
2 reasonable attorneys. Who knew? Who knew? Thank you, guys.
Thank you.